Good afternoon. We are a constitutional republic. Our government and our life as a people are characterized by the rule of law, even a fundamental law, crafted in 1787 by an assembly of rare genius, amendable and amended, but relatively unchanging, and revered for its wisdom, antiquity, and proven effectiveness. Since 2004, Congress has required by law that, quote, all publicly funded educational institutions or institutions that receive federal funding of any sort provide educational programming on the history of the American Constitution on this day. Whether or not that's any of Congress's business to be telling people what to do on this matter, this year, the King's College observes Constitution Day with an address by Seth Lipsky. The Boston Globe described our speaker as, quote, a legendary figure in contemporary journalism. A graduate of Harvard College, he served in the U.S. Army where he was combat reporter in Vietnam for the GI Daily, Pacific Stars and Stripes. He went on to play a role in launching 4 newspapers, the Asian Wall Street Journal, the Wall Street Journal Europe, the Jewish Forward, and the New York Sun, of which he is editor and proprietor. Jeffrey Goldberg, editor-in-chief at The Atlantic, called him the most interesting mind in journalism. He is the author of, among other books, The Citizen's Constitution, an annotated guide, which I have right here, and which you should have as well. You'd think there would be more books like this. The Constitution with all its detail and importance and going through each clause, giving gems and commentary. For example, you've heard of Donald Trump, the president. People are always talking about his impeachment. I don't know what they'd impeach him for, say some people. Other people, I don't know what we wouldn't impeach him for, right? Well, what does the Constitution say? The president and others shall be removed from office on impeachment for and conviction of treason, bribery, and other high crimes and misdemeanors. Well, what does that mean? One of the things Mr. Lipsky gives us. What then is an impeachable offense? So asked Representative Gerald Ford in 1970, who went on to become president, of course, when he was seeking the impeachment of Justice William O. Douglas. Ford famously answered his own question. The only honest answer is that an impeachable offense is whatever a majority of the House of Representatives considers it to be at a given moment in history. So it could be a GIF involving a golf stroke and Hillary Clinton at the other end. Whatever Congress decides. So he is the husband to Amity Shlaes, whom we know and love here at the King's College. They have 4 children and live in Brooklyn, New York. We welcome Mr. Lipsky to address us now on the separation of powers, the special prosecutor, and, quote, the boldness of the president. Mr. Lipsky.
Thank you, Professor Innes. I very much appreciate the invitation to be with you here at King's today. Thank you to President Thornberry, to Kimberly Thornberry. Is she here? I don't know if she's here, but she and I were communicating about a blurb for Josiah's wonderful book on the Electoral College. It's the second baby he delivered this week. Thank you, Dean Hidgley. It's a wonderful thing to mark in a formal way, as King's is doing, the day set aside to celebrate our Constitution. The Constitution, after all, is conceived of as a unifying document. It's the only parchment in our national life that all officers, legislators, and judges of our government must be bound by oath or affirmation to support. That requirement, by the way, is in Article 6 of the Constitution itself. And typically, as Professor Innes just gave us a little glimpse, it is followed by the word but. But, it says, no religious test shall ever, no religious test shall ever be required as a qualification for any office of trust under the United States. In other words, in the same paragraph in which the Constitution asserts its unifying powers, the document makes its most emphatic statement: no, ever, any, protecting each aspirant to government in America in her or his religious scruples. I find that very interesting. I especially appreciate this invitation because the topic that Professor Innes invited me to speak on, the separated nature of the powers in the Constitution, could not be more timely. I'd even call them urgent. It would not be going too far, in my view, to say that the principle of separated powers is today in crisis. This has been growing on us since the appointment of a special counsel to investigate the possibility that President Trump and his campaign, and some of those who are now his advisors in the White House, colluded, that's the word of the day, with the Russians to throw the election. Given the enormous powers that a special counsel has, and all of them directed at 2 or 3 or 4 individuals, I fear that the threat being mounted by the special counsel could affect the boldness of the president. It's not my phrase. The phrase comes from the pen of one of the Supreme Court's greatest justices, Antonin Scalia. He's now gone, alas. When he wrote that phrase, he was dissenting, he was the only dissenter, in a case known as Morrison v. Olson, which was decided in 1988. It was the case in which the Supreme Court allowed a law called the Independent Counsel Act to remain in force. It was a terrible mistake. The law grew out of the scandal known as Watergate, which eventually brought down President Nixon. As the scandal deepened, Nixon decided that he would move his defense secretary, Elliot Richardson, over to be Attorney General. In order to get confirmed, Richardson made a deal with the United States Senate that many of us felt at the time as well, was constitutionally irregular or even shocking. The deal was that Richardson would bring in a special prosecutor under a promise that the prosecutor could be dismissed only for cause. In other words, he practically had to commit arson or shoot somebody in order to be fired. Ordinarily, and we'll get to this in more detail in a moment, a president gets to dismiss any officer in the government for any reason, whether he has cause or not. He may not like the way the person cuts his or her hair. So it would not be too much to say that to get confirmed, Richardson colluded, to use the word of the day, with the Senate to abridge the powers of the very president who had appointed him. You with me? The special prosecutor who was brought in was a Harvard professor called Archibald Cox. If he had been a professor at King's, he would have turned down the job. He proceeded to subpoena President Nixon himself and refused to compromise. The president, understandably, then ordered the Attorney General to fire him. An insubordinate Richardson and his deputy both refused, and it fell to the Solicitor General, the third highest officer in the Justice Department, then a genius called Robert Bork, to do the constitutional deed. Eventually, the House began impeachment proceedings against the president. Its Judiciary Committee hired a staff and went after Nixon, and it voted out 3 articles of impeachment: obstruction of justice, abuse of power, and contempt of Congress. Just by the way, apropos of what Professor Innes said, one of the articles of impeachment voted against Andrew Johnson, the first of the 2 presidents to have been impeached, was that he had spoken critically of Congress. Before the House could decide whether to press charges, however, Nixon quit. And if this period of our history interests me, ask me during the question time, which I hope will be long and lively, to tell you about the head of that committee's legal team, Bernard Nussbaum, and his assistant, Hillary Clinton. The Congress proceeded to undercut, in any event, after Nixon quit, the Congress proceeded to undercut not Nixon, but the presidency itself. It passed a law known as the Independent Counsel Act. It established, as a matter of statute, that a prosecutor could be named by the United States Court of Appeals for the District of Columbia Circuit and could not be fired by the president. The constitutionality of the law was eventually challenged by one of America's greatest lawyers, Theodore Olson. When he was an officer in the Justice Department, he himself had been targeted by an independent counsel. Her name was Alexia Morrison. He challenged her right to be an independent counsel. He challenged the right of Congress to create an independent counsel. And the case went to the Supreme Court under the title Morrison v. Olson. And the Supreme Court allowed the independent prosecutor to proceed against Ted Olson. Their vote was 7 justices against Antonin Scalia. Justice Kennedy recused himself from the case. Scalia's dissent became a prophetic document. It's one of the most famous dissents in American history. I recommend it to each of you ardently. It's beautiful, beautifully written. And the justice began it by noting that it is the proud boast of our democracy that we have a government of laws and not of men. Many Americans are familiar with that phrase, Scalia wrote, but not many know where it comes from, or so he said. You with me? It turns out that it comes from the Massachusetts Constitution of 1780, Article 30 of which declares, and here I'm going to give you a long quote, "The government of this Commonwealth, in the government of this Commonwealth, the legislative department shall never exercise the executive and judicial powers or either of them. The executive shall never exercise the legislative and judicial powers or either of them. The judicial shall never exercise the legislative and executive powers or either of them, to the end that it may be a government of laws and not of men," meaning a government of law and not of dictators. That's where that phrase comes from. As Scalia noted that the framers of the federal Constitution similarly viewed the principle of separation of powers as the absolutely central guarantee of a just government. And why shouldn't they? The federal Constitution was written only 7 years after Massachusetts supreme law was put to parchment. And the leading author of the Massachusetts law, John Adams, was part of the Massachusetts delegation at Philadelphia. How many of you seen the TV series John Adams? Do not miss it. The brilliance of Scalia's dissent was in rooting the problem with independent councils in the doctrine of separated powers. It is, after all, the president who is the president, and only the president, who is enjoined by the Constitution to, quote, take care that the laws be faithfully executed, close quote. In the same sentence, he is also enjoined, in the same sentence in which he is enjoined to take care that the laws are faithfully executed, he is enjoined to, quote, commission all the officers of the United States, close quote. Just to mark the point, the Constitution does not say that the president shall commission officers of the United States. It does not say that the president shall commission the officers of the United States. It doesn't say the president shall commission most of the officers of the United States. It says he shall commission all the officers of the United States. It uses the word all. Now, one thing one learns when one studies the Constitution is its most radical feature. Amity and I were taught this point by Judge Douglas Ginsburg, then Chief Judge of the District of Columbia Circuit, over dinner one night after my book had just been published. The four of us, the judge brought his wife, and Amity and I were having dinner. And at the end of it, I said, Your Honor, you know, I've just brought out this book, Annotating the Constitution. Would it be appropriate for me to give you a copy? And he said, yes, if it's worth less than some specified amount. And I said, it's not even close to that. So I handed him a copy of it, and he opens it up, and he looks at the first, you know, this is a book that footnotes every phrase in the Constitution. And footnote number 1 comes after the phrase, we the people, footnote 1, and the footnote is, as opposed to the states. And the judge, who is a genius, looks at me and he says, you could have done better than that. You could have gotten more basic than that. And I said, well, how so, Your Honor? And he said, well, you could have footnoted the first word in the Constitution. And I said, well, I just written a book on it. I said, well, what is that? He said, the word is Constitution. It says Constitution of the United States right at the top. And he said, I would have footnoted that word. And I said, well, what would you have said? And he said, I would have said that its most radical element is that it's written down. Why did we write it down? The English Constitution isn't written down. It's just a bunch of concepts that kind of float in the air. And the answer is that we wrote it down because we wanted people to pay attention to its actual words and what they meant and transmit that over time. So that word all, when it says all the officers of the United States, it's important to know that they're not talking about some or most or several. They're talking about every officer of the United States must be and can only be commissioned by the President of the United States, just the way it is. And it makes only sense. How can the President be given the responsibility of faithful execution if he cannot decide which officers get commissioned and decommissioned? It was Scalia's great insight to understand that independence in a prosecutor can never be a virtue if the independence is from the President. Scalia grasped that any independence in executing of the laws would be unconstitutional on its face if the independence is from the President. You with me so far? So one might think, all that's well and good, but it's all theoretical. What is the actual problem? The problem is that the unmooring of an officer from presidential oversight exposes the prosecutor to perverse incentives and invites a kind of constitutional or governmental arrogance. An independent prosecutor gets an unlimited budget, all the staff he wants, office space separate from the Justice Department, office space separate from the White House. He could put locks on the door and no one could come in. They combine to create an almost irresistible pressure to keep going until the independent counsel can find something, anything if necessary, to justify his or her existence. It's not that independent or special prosecutors are bad people. The structure would tempt even an alabaster saint. Here is how the great Scalia put it. These are his words now, quote, "Unless it can be honestly said that there are no reasonable grounds to believe that further investigation is warranted, further investigation must ensue, and the conduct of the investigation and the determination of whether to prosecute will be given to a person neither selected by nor subject to the control of the president, who will in turn assemble a staff by finding out, presumably, who is willing to put aside whatever else they are doing for an indeterminate period of time in order to investigate and prosecute the president or a particular named individual in his administration. The prospect is frightening, even outside the context of a bitter interbranch political dispute." And then the famous words. Here they are. "Perhaps the boldness of the president himself will not be affected, though I am not even sure of that. But as for the president's high-level assistants, who typically have no political base of support, it is utterly unrealistic to think that they will not be intimidated." Scalia summed up with another famous line, "While issues often come before the court clad in sheep's clothing," he wrote, "this wolf comes as a wolf." Again, you might think, this is all theoretical, but what would you say if it were suggested, and I'm suggesting it, that our very lives, our children's lives, our future as a country could well hang on this principle? If that sounds improbable, feature what happened in the 1990s when an independent counsel was sicked on President Clinton. A widely respected judge, Kenneth Starr, was named not by Clinton, but by a panel of judges. He started with an investigation into the suicide of the deputy White House counsel, Vincent Foster. But then his mandate got widened to a whole raft of abuses by President Clinton, including his affair with a White House intern. Fair enough, one might say, and many did. It came out only later, and in an all too horrifying manner, that during this period, a multi-millionaire terrorist named Osama bin Laden was hatching plans for a war against America. Our intelligence agencies were on to him. And at one point, we had surveillance of an enemy lair in Afghanistan known as Tarnak Farms. We had drones hovering over it, ready for action. It was so serious that on 4 separate occasions in the spring of 1998, June 1999, December 1999, and August 2000, Mr. Clinton's national security advisor, Samuel Berger, was presented with plans to take military action against al-Qaeda. You with me? Throughout that period, President Clinton was being either investigated or impeached or on trial in the Senate or in dealing with the aftermaths. Each time a proposal for action went up, his national security advisor proved to be an obstacle for action. He failed to act. He failed to get the president to act. Had he been a little less reluctant to act, a little more open to taking preemptive action, a little less concerned about the president's political predicament with a special prosecutor in the Senate, maybe 2,973 persons killed on September 11, 2001 would be alive today. It is not my intention to suggest that Mr. Berger, a patriotic American, or any other American, is responsible for those attacks. Only Al-Qaeda bears that burden. It is my intention in relating this story, and the details are outlined in the official report of the commission that investigated 9/11. Its report was published in the summer of 2004. It is my intention to mark the point that Justice Scalia was making about separated powers. Remember, he warned not only about the boldness of the president, he also warned about the boldness of his staff. And once an independent prosecutor is on the prowl, he has the capacity to frighten, to paralyze the whole administration of government. Why was it Mr. Berger, rather than President Clinton himself, making all these judgment calls, the New York Sun asked in an editorial at the time? It noted that the 9/11 Commission's report found that the key decisions were, quote, made by the Clinton administration under extremely difficult domestic political circumstances. Opponents were seeking the president's impeachment, close quote. Commented the Sun, one can blame the special prosecutor law or Mr. Clinton for agreeing to name a special prosecutor, or one can blame the underlying reckless behavior by Mr. Clinton that got him into the difficult domestic political circumstances, or one can blame the Republican Congress. No matter what one's view of the underlying merits, the Sun said, it is hard to deny that one of the costs to the country of an independent counsel investigation in violation of separated powers was a preoccupied president. There's no guarantee that in absence of the scandal and the prosecutor, Mr. Clinton would have acted against bin Laden. We just will never know. Yet it's hard not to reckon that the chances would have at least been increased. And the Sun concluded, the boldness of the president, in Justice Scalia's phrase, had been lost, and the man left in charge was not up to the task. One of the most astonishing features of this story is that democracy works in resilient ways. Even though the Supreme Court had ruled against Olson by 8-1, the country came to understand that the court was wrong and Scalia was right. And luckily, the Independent Counsel Act was one of those laws that had a sunset provision requiring it to be renewed every few years. I think it was every 10 years, but in any event, requiring it to be renewed from time to time. And when this deadline came up in 1999, the Congress let the law die. By the way, there wasn't even a fight about it. The Republicans, the Democrats, they all agreed. The Republicans still remembered that Reagan was set upon by an independent counsel. The Democrats were still smarting over the way Clinton was set upon by an independent counsel. And nobody objected. I don't think there were, I haven't checked this, but I'd be surprised if there were half a dozen newspaper editorials objecting to it in the whole country. Now let's fast forward to today. It's been a generation since the grueling investigation of Mr. Clinton by a special prosecutor, followed by the president's impeachment and trial in the Senate, which acquitted him outright. Now a new president is being pursued by a special counsel in violation, in my view, of separated powers. Technically, people will tell you, you'll read about this in the paper, a special counsel is different from an independent counsel. The special counsel was appointed by President Trump's own Justice Department. Technically, he could fire the special counsel. But the problem, deep down in the journalistic sense, in the broad constitutional sense, in the political sense, the problem is the same. The boldness of the president is in danger because we have turned our back on the American bedrock of separated powers. Today's situation, one could argue, is even more dangerous. We are facing not only the Islamist threat of which bin Laden had been a part. We are facing that threat, but not only that threat, we're also facing a nuclear-armed North Korea firing missiles that, it is just demonstrated, can reach Japan, and that it warns will soon be able to strike our own American soil. We face a communist Chinese regime maneuvering in the South China Sea against us and our friends, with some of whom we have formal treaty obligations. Russia is marshaling its forces opposite Eastern Europe and in the Arctic, and Iran is maneuvering against us in the Middle East. If ever there were a situation in which our president, no matter who he or she might be, if ever there were a situation in which our president has to be bold, this is it. Should we be worried that President Trump's boldness might be affected by what the special prosecutor, Robert Mueller, and his staff are doing? Should we be worried that Mr. Trump will prove unable to keep his courage? Should we be concerned that his advisors might crumple the way the 9/11 Commission report suggested Mr. Berger did? The answer I want to leave you with is that the founders of America certainly would have been worried, which is why they separated the powers to begin with. Does this mean that a lawless president can't be curbed? Not at all. There is an unambiguous power granted in the Constitution to the House of Representatives to impeach, meaning to investigate, and if the House deems it appropriate, to accuse the president. There is an unambiguous power, a duty even, granted to the Senate to try the president in such circumstances. Congress has the power to remove a president from office and ban him from holding further office. Once he is removed, though, the Constitution specifically states that the party convicted on impeachment shall be liable to indictment, trial, judgment, and punishment according to law. Almost no one has suggested things have ripened to impeachment until history and the Constitution suggest putting a premium. But that is what would be required. And history and the Constitution, meantime, suggest putting a premium on the boldness of the president. So now I would like to invite you to ask questions on separated powers or anything else that you think might be appropriate on Constitution Day. But before I invite, and to encourage you to let it rip, let me just, to encourage you not to be shy, let me just say, the Constitution has befuddled even some of our greatest sages. And one of my favorite stories on this was told to me by an acquaintance, one of America's greatest lawyers. And he tells of his arrival at the Supreme Court as a clerk to Justice Lewis Powell. On the first day at the court, the clerk introduced himself to the justice's private secretary. Then he leaned over to the secretary and he whispered, "Is there anything in particular that I should keep in mind?" "Yes," the secretary said, "there is one immutable rule around here, and it is that fish and Indians always win. If a case involves fish, they win. And if it involves Indians, they win." It was a fascinating bit of advice. And there it was, until one day, not long into this clerk's tour of duty, there came before the court a case involving a dispute over how many fish an Indian tribe in the state of Washington could take from a river that ran through their reservation. Or, to put it another way, we can all construct our theories, but at the end of the day, both the fish and Indians cannot win all the time.